some interesting discussion coming up. There are a few testimonies that you may not have gotten yet or that you might have gotten late. And when we have those, I will let you know to be looking for those in your electronic documents that Kathy so graciously has sent out to us and done such a good job. Okay, we're going to go ahead and open the hearing on House Bill 2599, and we will have Natalie, our reviser, go over that with us.
Thank you, Madam Chair. House Bill 2599 prohibits charges for electronic copies and determinations of whether a record exists under the Kansas Open Records Act, and it also limits charges for employee time required to make records available under the Act. The bill amends KSA 45219. That's the statute in the Kansas Open Records Act that sets out the fees to be collected when producing records. Current law there provides that fees for access to or copies of records within the executive branch shall be established by the agency head. The section also provides that a fee for copies that is equal to or less than 25 cents per page is deemed to be a reasonable fee. This bill would provide that those fees for records within the executive branch shall be established by the agency head, and that for printed copies, the fee must be equal to or less than 25 cents per page, and that no fee shall be charged for electronic copies of records or for the cost of employee time required to make records available. A fee shall not exceed the lowest hourly rate of an employee qualified to provide those requested records. No fee shall be charged for a search to make a determination whether the requested record exists, or for any employee or administrator review of the records. And then the provision deeming a fee equal to or less than 25 cents per page is removed, since those fees are now going to be required by law to be at 25 cents per page or less. And I can take any questions.
Okay, thank you so much. Committee, do you have questions? Okay, thank you, Natalie. Okay, we're going to hear proponent testimony first. I'll call up Dave Traubert from the Kansas Policy Institute. Welcome, Dave. Glad to have you in committee.
Thank you, Madam Chair. I think this is my first time in Judiciary. We're usually in tax
or just this year?
No, I think maybe ever.
Oh, wow. Okay.
Yeah, this is a treat. So good afternoon, ladies and gentlemen. My name is Dave Traubert. I'm CEO of Kansas Policy Institute. We're pleased to be here to testify in support of House Bill 2599 so that taxpayers are not overcharged for obtaining public records. The law currently says that charges cannot exceed the actual cost. And as the reviser mentioned, there is a statement that says 25 cents or less per page will be deemed reasonable. If you put those two statements together and you know that it costs maybe a nickel or less to print a page, it's reasonable to see that the legislative intent was that 25 cents would cover employee time and the cost of printing. Unfortunately, we're seeing a growing trend of some local agencies of government, cities, counties, school districts, and so forth, to charge both. They'll charge 25 cents, even if you don't get a piece of paper, they'll charge 25 cents per page plus the cost of employee time. Another way that costs are artificially inflated is having high hourly rate people do the work when someone, like an accounting question, could be easily answered by a payroll clerk or an accounting clerk. It's not unusual to see hourly rates of $65 or more charged for rather routine searches. There's also a growing trend to charge for employee time to get the records and then for managers to review the records. And I understand there can be a case made where you might want to have someone review it, but this is an opportunity for that part to get out of control. And it's not unusual to see the cost of reviewing exceed the cost of actually gathering the information. I'll give you some examples. Oh, they also start charging for electronic copies. Most people don't get paper copies anymore. Well, it doesn't cost anything to send an email. It doesn't cost anything to attach an electronic document to an email. And yet many local units of government are starting to charge per page for electronics. Now imagine you ask for a 50-page document, they want to charge you per page for that, even though the cost was zero. There's examples like USD 257 IOLA, and it's on their website. They charge $1 per page. They also charge a flat $300 fee for corporations. There's nothing in the law that allows any entity of government to distinguish who pay, you pay a higher rate just because you're a business. There's one district we had that's charging now for employee benefits as well as the hourly rate. The benefits don't change. No matter what that employee does, it does not increase the cost. This is just another creative way of increasing. One of the most egregious examples we've had of was a few years ago from the Kansas State University. We asked for copies of employment agreements. They sent us a letter saying we need $9,600 up front so that we can hire someone to determine if we have any employment contracts. That was clearly a go away price. Now, it's these kinds of things should not happen. Unfortunately, they do. And I would say that state agencies, doesn't matter whether it's a Republican or Democrat in charge of in the governor's office, state agencies have been very good over the years in not only responding quickly, but with very reasonable prices. The challenges are with some, not all, but some of the local units of government. And finally, I would ask the committee to consider an amendment to this bill. As it's written, it seems to only apply, these changes in rates only apply to the executive branch. We believe these same charges should apply to every unit of government, not just the executive branch. And with that, Madam Chair, I'll be happy to stand for questions at the appropriate time.
Thank you. I think we'll go ahead and do questions now. So,
Okay.
Yeah. Committee, do we have questions for Mr. Traubert? Representative Smith.
Thank you for your testimony. I'm looking through the fiscal note. Have you seen the fiscal note that's been prepared for this bill?
I have not.
In the fiscal note, a little over $500,000 is what it's going to cost the state in order to do this. And then the other part of that is my concern looking at KBI, the Office of the Attorney General, and the time constraints, or not time constraints, I'm sorry, the file sizes of some of these electronic files can't be kept locally. So they're having to put them on removable media. And that removable media then has to be located, replicated, redacted, et cetera, because of the nature of the cases, what have you, depending on who is making their request, obviously.
Sure.
Are those considerations in the bill? I haven't gone through it to make sure, but.
Well, I'll start with that one first,
Sure.
Representative. There's nothing in the bill that we see that prohibits an agency from charging for whether it's in your file cabinet, it's in a salt mine, it's wherever it is. That's a cost of going out and gathering the information. So the agency would be able to charge for that. It's just that you can't charge per page plus an hourly rate. You can't charge $100 an hour when a $30 an hour employee can do the work. That's what we're trying to get at. It doesn't. It would impact, none of the examples you gave there would be an impact of this bill as we read it.
Okay.
I would be amazed to see how that fiscal note was prepared. A fiscal note would indicate it would cost more to do this. No one's going to spend more money. No agency is going to spend more taxpayer money to get this. This would only limit the amount they're allowed to charge. I mean, employees work and they go home. If they do something today, they're going to do something else tomorrow. It doesn't change the cost. And so there's the fiscal note in that case, I would say, is perhaps a little overstated.
Yeah, so I'm going through it, and I am seeing some things that really make me question. For instance, the Attorney General's office saying they need 2 more positions than to take care of this bill. So I'll look at it a little closer. Thank you, Madam Chair.
Any other questions, committee, for Mr. Robert? Representative Mon.
Thank you, Madam Chair. So this is kind of rhetorical. I know the answer to it. These are public records that we're talking about,
Yes,
and that the departments have a duty to provide.
absolutely.
We should work on getting the costs down as much as possible. Thank you.
Any other questions? Okay, thank you so much for your testimony. Okay, I will call up Rachel Schrag from KSNW TV. Is she here? Is she online?
I am online.
Okay, thank you. And Rachel, did you happen to send your testimony? You did get it. Okay. All right. So, committee, I think that testimony may have just be coming in, but Rachel, welcome to committee. And, you may go ahead. Let's test and see if we can hear you.
All right, just double checking you can hear me.
Pretty well, but not a great.
Does it help if I project a little bit more?
Very
Use
much.
my anchor voice.
Don't use your anchor voice, please. No, but that's we can hear you now. Thank you.
Okay.
Please go ahead.
To clarify, anchor as in news anchor, not angry. Just to clarify,
Okay.
I'm not angry. My name is Rachel Schrag Sommerfeld. Thank you so much for allowing me to testify in support of House Bill 2599 regarding limiting fees charged for copying and staff time for open records. I am the news director at KSNW TV in Wichita, Kansas. I have been a journalist in this state for nearly 25 years, working in both print and broadcast mediums. It is essential that open records in Kansas must be available to the public and to journalists. It's a vital part of our process for ensuring that our government is held accountable to the working people of Kansas. Excessive costs for Cora fees prevent individuals and journalists from being able to gain access to records that are meant to be open for a reason, so that Kansans can be aware of what is being done with our tax dollars. However, excessive Cora fees are not uncommon in Kansas. As an example, in 2018, KSN requested records from the Department for Children and Families in the case of Anthony Bunn, known as Tony, a 2-year-old Wichita boy who died at the hands of his mother and her boyfriend. The mother is now serving 19 years in prison, the boyfriend 48 years after pleading guilty to second-degree murder. KSN learned that DCF had been involved in Bunn's care and had investigated several reported cases of abuse and neglect prior to the child's death. KSN journalists wanted to see how DCF had handled these cases and could more have been done to provide services to this boy, preventing his tragic death. KSN requested all documents regarding DCF and any involvement with the cases involving Bunn, including parents, guardians, and the mother's boyfriend. We were given an estimate of $493 for 552 pages of documents, including 10 hours of labor at $38 an hour. The first 100 pages were provided without printing costs per then Governor Jeff Collier's executive order. The rest were billed at 25 cents per page. When we received the documents, we only received 429 pages, not the estimated 552. And we did not discover this immediately, so we did not request a refund when it was discovered. Of those 429 pages, 214 were either entirely blank or entirely redacted. That includes 74 pages that were either blank forms that appeared to have been printed off but never filled out, providing no information or data, or pages that were simply blank pieces of paper with no information of them. Another 40 pages were redacted in their entirety, the vast majority of pages that included a large black rectangle box over the entire page, not leaving any piece of information on the paperwork. I do understand that there are some items regarding the Wichita Police Department's investigation that would be redacted, and we fully understood that some personal identifying details would be redacted for privacy. However, at 10 hours of labor charged at $38 an hour, I would have expected the redactions to be more precise instead of blacking out entire pages, rendering the documents useless. It's unreasonable that we would be charged nearly $500 for records when half of the documents provided had no information or were entirely redacted. At the time, KSN was investigating multiple child deaths in which DCF had been involved in the case prior to the child's death. That includes the case of Evan Brewer, the 4-year-old Wichita boy that died after months of torture at the hands of his mother and her boyfriend. In response to a KSN open records in that case, the agency released documents and admitted documentation regarding DCF's checks on that child had been changed by an employee after the child's death, changing it to say that a DCF employee had followed up on a concern with the family when that in fact had never happened. As you likely know, this case, among others, prompted changes within DCF, including the new legislation to increase transparency and multiple procedural changes within the agency. KSN agreed to split the cost in some of these DCF cases with the Wichita Eagle to lessen the financial burden on each of our organizations and to allow more requests to be public. But had KSN, the Eagle, or other journalists not been able to afford these documents, prompting questions to lawmakers, DCF, and others, would such changes have happened? Would efforts have been made to protect the lives of vulnerable children, and had the lapses in procedure not been documented, if not publicized through Open Records Act request? KSN is a founding member of the Wichita Journalism Collaborative and has been an active member since its inception in 2020. It is a coalition of newsrooms and community partners joining forces to help meet the news and information needs in and around Wichita, enhancing quality local journalism. It includes KMUW Radio, the Wichita Eagle, the Community Voice, the Wichita Beacon, the Sunflower, and Planeta Venus, among others. Before this testimony, I asked my colleagues with the Wichita Journalism Collaborative what they had experienced regarding costs of open records. One member told me they were initially charged $12 for a document that was readily available from the city of Wichita, a report that had been submitted to the KBI. No additional research was required. It was simply a document that could have been emailed. Eventually, the city agreed to drop the charge. Another colleague told me they were looking into death records and were told some items were being held at the salt mines in Hutchinson. While they expected the cost for this request to be higher than most, they were shocked to receive a cost estimate of $8,586 to retrieve files and compile information. Other members recalled having to pay a standard $50 or $55 fee for research to determine if files were available. HB 2599 would ensure that fees would not be allowed simply to search to see if those records exist. Journalists, and I say we are journalists because that is what we are. We're not the media. We are the fourth estate for a reason. We're here to be the checks and balances to ensure that no political party, no lawmaker, no taxpayer-funded agency is taking advantage of Kansas's money, trust, or their liberties. Unfortunately, there have been cases in recent years where KSN has declined paying a KORA request due to the excessive cost. Those records meant to be public and available to all Kansans were never revealed as we didn't have the budget to pay for them. I know our organization is not the only one. Many news organizations in Kansas are very small operations working with limited staff and budget. It's essential that lawmakers that value transparency and have nothing to hide from their constituency support HB 2599 to ensure open government in Kansas. Thank you for allowing my testimony and for hearing me out and to discuss this important issue. And I am available for questions. Also in the document I provided, there are some examples of the blank and redacted pages from the DCF case I mentioned.
Okay, thank you, Rachel. Appreciate that. Committee, you have questions for Rachel? Representative Titus.
Thank you, Madam Chairman. Rachel, nice to have you with us today. So this bill is interesting to me personally because I think I'm uniquely qualified to think about it because I was a journalist before I went to law school. So I've run a one-person newsroom and dealt with all the difficulties that has with no staff. And I've also been chief attorney at a state agency, and I've had to deal with a 15,000-page request that needs to be redacted. So a lot of the things you say are good. I've gone to my local county and asked for a budget for the local police department, and they charged me $18 to print off spreadsheets that were the last 10 years of budgets that were readily available, and it infuriates me. So I appreciate where you're coming from there. But at the same time, when you get a large batch of documents, or I'll tell you, the state IT is not really precise at pulling an email request of, even when you give them good dates and people, it still results in way more emails than anybody wants to review. How do we balance the burden? You have a small newsroom, but some state agencies only have 1 or 2 people to look at 10,000 emails. How do we balance the burdens between you getting information and the state agency not having to shut down, 2 weeks of enforcement work to review a request?
Well, to me, I think part of it comes down to the element of the time frame and what is allowed in law of how much time we have to. I believe it's 3 days to be able to respond to the initial core request, but then there is time given, a reasonable amount of time to be able to get those elements and be able to provide. And I'm sorry, I don't know the exact dating as far as timing, but it is not expected that we be able to that everyone drops everything to provide those documents to us immediately. It is allowed to take some time and some of that staff time to be able to do that. And so I think, along with any other expectation, because these are open records that should be available to the public, finding a way to balance those details amidst the other responsibilities is part of the responsibility I see that the law requires.
Representative Carmichael.
Ms. Summerfeld, I appreciate you being here.
Thank you.
I empathize with you. The fourth estate is not the only people who suffer because of similar experiences. And I want to pose to you circumstances that I've run into as a state legislator on the Evan Brewer case, for example. DCF, as I recall, wanted to charge me a lot of money for records that I needed for use in this very committee. And I never got all of the records that I wanted or that I needed. City of Wichita has charged me hundreds of dollars for records that were necessary to represent my constituents in connection with insider dealings at the planning department in Wichita. As I understand it, at least as of 10 years ago, the policy here was that if we used our legislative research service to request documents from state agencies, that they could pay up to $25 to obtain documents, but the rest of it would be on the state representative or the legislator who asked for the documents. So I want you to, and that may not be the case today. I'm not sure how that fee schedule works, but I want you to know that it's not just the fourth estate that encounters this. It's the, what are we? The second estate, I think, the legislature itself. And so I empathize with you. I can't find any good excuse for the types of estimates that I've received other than to try to keep the state legislature from having access. So I want to encourage KSN and the other members of the consortium to keep shining that light into those dark corners because it needs to be done no matter what the cost is. Would you agree?
I absolutely agree.
That was my first question, Madam Chair, but I do not have a second.
Thank you. Representative Lewis.
Thank you, Madam Chair, and thank you for being here. I have, I sympathize with your concerns. I have a question about the actual bill. It seems to me there's first a contradiction in it, and I'm not sure how it would work. It first says that for the cost of employee time required to make records available, a fee shall not exceed the lowest hourly rate of an employee qualified to provide the requested record. So for instance, somebody's $80 an hour and you can do it for 40, you use the $40 an hour employee. That's understandable. But then it goes on to say, no fees shall be charged for a search to determine whether the requested records exist or for any employee or administrator review of such records. So the paragraph that I just read said you can charge to make the records available, but then you can't charge to search for them or to review for them. So I'm not clear on that distinction. And my second concern is that if these are, for instance, emails, which Representative Titus mentioned, or electronic data, you know, it can be very expensive to actually search and find those. And also it can be very expensive to go to the salt mines and find them. So those are my concerns, that it may put the public entity in a real fiscal bind. Could you respond to those concerns?
I understand the concern that it does cost time to obtain those records. Regarding the first question you asked, searching for, we have oftentimes received bills, invoices to essentially pay an invoice to search to see if such a record exists. For a long time with the city of Wichita, if I recall correctly, it was about $56 each time we put in a request. We have to search to see. Well, $56 times how many times you're doing that, then on top of it, finding the documents and going through the proper redactions and all those times that would require the staff hours at the lowest paid reasonable rate would go on top of that. And so I think, if I understand correctly, this getting rid of that initial search to see if those records does exist would take away some of those costs. I would also say as well, regarding some of the excessive fees, such as the salt mines, my colleague did make the comment they expected it to be a larger cost to be able to get that, drive someone to Hutchinson from Wichita to be able to get those items and retrieve them. But having almost $9,000 be the expectation for that staff time to do that seemed unreasonable in my colleague's perspective, and to me that also seems somewhat unreasonable. And so I think what our concern is making sure that the costs are reasonable, and having this rule and these expectations is what I believe this bill would do, to make sure that they are not excessive costs.
Go ahead.
Thank you. Another question on what the bill means in practice. It says you can't charge for administrative review. How would you view redacting those as part of the administrative review, or would you view that as making the records available for which we under the bill could be charged? I'm a lawyer, especially as a younger lawyer. I was involved in major discovery, and it costs a lot in terms of time and effort and so forth to respond to requests and review them, make sure that they're responsive, and then redacting what's not responsive. It's not always an easy task.
And so the question is regarding whether the fees can you rephrase that one more time for me?
Yeah, sure. The short question is, if you get the documents, somebody has to review them to see if there's something that should be redacted for various reasons, or to see if they're responsive. Is that something that under the bill as proposed could be charged or not?
I guess I'm not sure that I have that capability to know exactly in the wording how that process would work, but my understanding is the staff time that would be required to be able to put together these records once they've been found could be done by the lowest paid individual who is qualified to do that work. And if the lowest paid individual who's qualified to do that work is a lawyer who requires a higher cost than, for example, a clerk, then that would be the lowest paid individual who could be doing those doing the process of gathering and redacting those elements, is my interpretation. But again, that may be out of my purview.
Okay, thank you. Other questions, committee? Representative Titus, go ahead.
Thank you, Madam Chair. And Representative Lewis does bring up an interesting point. I suppose the first couple of changes actually make quite a bit of sense to me. But the last one about not charging for review, my experience is if there's not some limit on requests, people always request as much information as possible, which is great. But it does sort of depend what your job is, and if everything could involve a potential attorney review. I mean, it's really not a stretch to shut down an executive agency's legal shop, especially the smaller agencies, for days to work through some of these requests. So I guess I would pose the question, is if it's more about reasonableness, would there be tweaks to this law that would say any request less than $100 no agency shall charge for. So we get rid of some of the ticky-tacky searches, because I agree that's charging $56 just to type in the search words. That's not really the intent of the law, in my opinion. So things like that, and couching fees shall be reasonable in excess of a certain number. Would changes like that be helpful to try out before we jump to some of the extremes that could result from this, although well intentioned?
Well, I would argue that I think, anything that helps make records more accessible and not excessively costly helps. I think part of where this helps and is important is the reality that I don't think that lawyers are going to be responsible for taking a look at the vast majority of the open records requests, at least that I have experience with investigating. For example, DCF, Wichita Police, etc. I think the initial review being done by an individual, there's plenty of people who are allowed to see confidential data within the Wichita Police Department or within DCF. That's part of their expectation. They don't necessarily have to be a lawyer to determine whether or not those elements are out there. So I would challenge that perspective to say that that individuals, that cost of doing things at a lower rate doesn't necessarily mean lawyers will always have to be doing that. I would certainly support anything that puts limits on those perspectives of how much excessive costs and how much costs can be held. And that's where I see as a supporter and proponent of this bill. The wording on $100 or a certain amount of thing, I think that was the perspective from then Governor Collier that said the first 100 pages from the executive branch would be free, and that helped to a degree. And I think this bill would be the next step to kind of move it to the next step in this process.
Okay, thank you, Rachel. Thank you. We really appreciate you joining us today.
Thank you.
Committee, we have written proponent testimony from the Kansas Press Association, Debbie Detmer, Jill O'Connor, and Missy Levitt, who are constituents. We are going to go ahead and hear neutral testimony now, and then opponent. Neutral, John Goodyear from the League of Kansas Municipalities. Please join us. Welcome.
Thank you, Madam Chair. Committee, good afternoon. My name is John Goodyear. I am the General Counsel for the League of Kansas Municipalities. Grateful for the opportunity to offer some thoughts on this legislation. Just as a starting point, the League and our member cities do support the transparency guaranteed by the Open Records Act. In order for government to be good, it has to be open. So we do value that, but we also support the continued ability of government entities to assess reasonable fees that are associated with the provision of records. And I just want to start by explaining our neutrality on the legislation today. Our reason for being neutral on the bill is that the text that was presented, the text that's before you, is not applicable to local governments who are our members. We're an association that represents local governments. So we can question the public policy, we can question the value of the legislation, but because it didn't directly affect our members, we stood neutral. But hearing from conferees that the goal of this is to ultimately get it to everyone, it switches our posture towards opposition, and I imagine it would do so for many of our member cities. And the reason being that there are costs associated with filling an open records request. We can say that there's not, but there are. That's realistic. It takes time to review records. It takes time to go through and redact records. We've noticed that we value redaction because we want to preserve and protect certain privacy interests, certain security interests. Those are codified in law. We're not just going through and redacting and withholding information that shouldn't be open to the public. We have to have a stated reason for that redaction, and that does take time. And this isn't an elimination of those costs. Those costs are always going to exist. It is a shift of who pays for those costs. Instead of the person that has requested the information, this shifts the costs to the taxpayer. It is our belief that there should be some fee associated with it. And another thing to highlight here is that the Open Records Act does a good job of protection. The language of it, we view, has protections in it. For entities are limited to charging their actual costs. We can only recoup our actual costs. This isn't meant to be, and it shouldn't be, a profit mechanism. it is limited to those actual costs. And if an entity is charging more than the actual costs and can't demonstrate those costs, there is penalty for that. There was a public agency relatively recently that charged more than was deemed reasonable, and they paid a penalty. That the Attorney General found that those fees were not reasonable. So there are mechanisms in place to ensure that we're abiding by that provision in law, that those costs be reasonable. Doing some quick research on this today, committee, all 50 states have some form of freedom of information, some kind of public records law, and all 50 states allow for the collection of fees, costs associated with filling those records. 42 states explicitly state that you can collect either staff costs or actual costs that are associated with filling the records. So we're certainly not alone in the fact that we do this. So just highlighting that and explaining our neutrality for the position for the bill before us. If that were shifted to apply to everyone, that would shift to opposition. And Madam Chair, I can stand for questions at the appropriate time.
Okay, thank you so much, John. Committee, do you have questions for John? Okay, Representative Carmichael, go ahead.
Thank you, Madam Chair, and thank you, Mr. Goodyear. Your testimony has been of value to this member of the committee, because I'll be in touch with the reviser to see if we can't broaden the scope of this good idea to make sure that your members get an opportunity to provide documents as well under the same circumstances as the state. But my question to you is, I think you acknowledge that maintaining records and providing records to the public is a governmental function. It's part of what we expect our government to do, and I think you pointed that out in your initial remarks. But here's my difficulty. This, I fear, is remedial legislation, which has only arisen after years and years of abuse. Years and years of agencies and governmental entities at every level trying to frustrate legitimate requests for information by imposing excessive fees and forcing people, if they don't like it, to either complain to the Attorney General and hope that the Attorney General, with all of the demands on his staff, will have time to pursue it, or to literally file an action in the district court. And what I see is that in view of the past abuses, that the state and municipalities are going to have to bear the consequences of what they've done for many years. And that means we paint with a broad brush. Why shouldn't we do that in view of what's transpired?
So, Representative, I would argue that part of the function of that fee shifting, that not fee shifting, but that ability to collect those reasonable costs that are associated with filling requesters from those that request it, is a function of being good stewards of the public's money. Representative Titus referred to some of the requests that these entities get. So there was a city a number of years ago that received a request for all emails that had the word water in them through a 6-month span. After efforts to narrow down that request, the requester didn't, so they filled that request. But the time that it took to go through and fill those records requests, there is some scenarios, and not all legitimate. Many requests are legitimate. There are some scenarios where the request is made with the intent of derailing government, and there are requests that are made where is someone that has legitimate other governmental duties to do, but they are taken off and doing this other legitimate government duty, but it is taking them away from something that they could and would be doing if they weren't put onto this longer or more arduous or extensive request. So it is a function of making sure that we can recoup costs. It's not intended as a profit mechanism. It truly is. We should be able to recoup costs associated with filling a request.
And a second question, if I may, Madam Chair. recognizing that you believe, and probably rightfully so, that there could be abuse by some individuals in particular, and I can think of certain groups that we all know of who are prone to abusing open records requests and lien filings and the like. And in view of the past history of what I believe to be active concealment of information by certain municipalities as well as governmental agencies, would it be a satisfactory solution to those abusive instances that we give the agency or municipality that holds the records and feels like that they are being taken advantage of and treated unfairly by overbroad records and expensive records requests, that we put the burden on them to file with their money an action, say, in the district court to say, Your Honor, this is not a legitimate records request. This is abusive. And under these circumstances, Judge, you ought to assess the reasonable fees and expenses of copying the materials. And you provide evidence to the court to show that's the case and how much it costs. And then in these rare instances where you're being abused, the judge can provide you with relief. Would that be satisfactory?
Well, Representative, regardless of whether it is a well-meaning request or a request that intended to derail government, requests have costs associated with them, and it should be the baseline that we can recover our actual costs. That is the position of the league.
Thank you, Madam Chair. I would observe that fire departments have costs too, but they're a governmental function and we pay for it out of our taxes. Thank you.
Thank you. Questions, committee? I did have a quick question. You saw in the bill where it does use the word reasonable fees. And then it also is, the cost of employee time required to make the records available. You can charge the 25 cents or that cost. I mean, you did see that in the bill, I'm assuming.
Yes,
It
Representative.
seemed like some of your testimonies seemed a little bit different than that.
So the concern primarily is with that subsection B, that 5B, and it's because of the reasons Representative Lewis highlighted. It does seem to contradict other places in the Act. There's probably some room to figure out better language here, is our position.
Okay, that's helpful. Thank you. I appreciate that.
Thank you.
Clarification. Yep. Okay, committee, we also have neutral written by Shannon Kimball from Kansas Association of School Boards, Thad Snyder, and Brett Anderson, who are constituent citizen. And there's also testimony from Clay Barker from the Secretary of State's office that you may have been sent a little bit later, not in the packet. So please make sure you take a look at that. Okay, and we will now hear from Jay Hall from the Kansas Association of Counties. Committee. Oh, excuse me, Representative Heiberger.
Thank you, Madam Chair. If I could just one question for the previous conferee.
Yes, John, do you mind coming back up?
And thank you for catching that. I appreciate it.
Yep, go ahead.
I'm ready for you, Representative.
Mm-hmm.
All right, thank you for being here today. I used to work as the Open Records Officer for Health and Environment for years and years. And I saw both sides of it. And I saw certainly the unreasonable requests that were just designed to slow down government. And also I saw us maybe charging more for things than we ought to. But it seems to me that this statute keeps the requester having skin in the game. It seems like the balances those two things fairly well. And so, I just wanted to know if you agree with that, and if not, how would you balance those things differently?
Representative, I agree with that to a certain point. Concern, and I highlighted this and I should have done a better job with this, is the section on that subsection B. No fee shall be charged for search to determine whether the record exists or for any employer administrative review of the records. That's where typically your real cost comes from. And we are concerned that an inability to recoup costs there will be burdensome. An inability to recoup those costs will make government more expensive, result in increased taxes, shifting that burden to the taxpayer rather than the requester.
So do you have a better idea, a better way to keep the requester have some skin in the game without being burdensome on the agency? So did you hear that?
Yes, that if we can find the right language there, we would be willing to help find it.
Thank you.
Okay, thank you. Thank you, Representative Heiberger. Nice to see you. Okay, so again, Jay, if you'll come on up. Thank you.
Yes. Thank you, Madam Chair, members of the committee. I am Jay Hall, Deputy Director for the Kansas Association of Counties. As you see in my testimony, I talked about just the process of open records, and we do at the Kansas Association of Counties support open government access to records. I myself do open records training for county officials on an annual basis. And in that training, as I mentioned in my testimony, I encourage them to, as much as possible, get records to constituents for either for free or for as low a cost as they can. So if, for instance, they have the record immediately available, I encourage them to just give that record out. If they need 10 minutes to find it, again, just give that record out. Don't slow down the process by attaching fees to that. However, that's a lot of the records requests that are received at the local level. That is, however, not all of the records requests that are received at the local level. We do receive complex records requests that request all of the emails dealing with a certain subject over the past 6 months, or all of the communication between a particular set of individuals over a certain period of time. When you have those types of requests, those are more complex requests because you have to look to make sure that you are getting all of those records. We don't want to go and say, oh, okay, they said they want all of the records, do a small cursory search, and then hand over 10 documents or 15 documents and not discover the other 10 or 15 documents that were held in a different place, or that you didn't realize initially were available. And so we want to make sure that these record searches are thorough and that we can recover those costs for doing those searches. The other thing, and I want to echo what Mr. Goodyear said when he talked about shifting the burden. Kansas is unique in that we are one of the states that allows anyone to request records regardless of whether they live in that particular city or county, or even if they are a resident of this state. And so that means that an out-of-state entity could make a large records request that is burdensome on the state government or on a local entity. And if this were in place, that out-of-state entity would essentially pass those costs on to the local taxpayer. I don't believe that's the intent of this committee, to allow out-of-state entities or other entities, because they can still request those records and we have to be responsive to that, to pass those costs on to the local taxpayer. So I just want to make sure that the committee is aware of that potential risk, that because Kansas law allows any entity to request records from any governmental entity, that those costs could potentially be passed on to local taxpayers. That's something that actually happens. We receive records requests through our counties from a lot of different entities, particularly over the last few years with relation to both health department information as well as election information. We've received a lot of records requests, not just from Kansans, but also from individuals that were out of town or even out of state. And we want to make sure that we're not passing the costs of those record searches on to our local taxpayers. I'd be happy to stand for questions at the appropriate time.
Thank you so much. Committee, do we have questions? Okay, I think, oh yeah, I'm sorry. I'm sorry. Representative Carmichael, did not see you.
That's okay. Madam Chair, I'm trying not to jump in ahead of my colleagues. So sometimes I'm a little slow, but I can even put my finger up.
We won't
Go ahead and
forget
pick
you. It's okay.
Yeah, don't pick me. Mr. Hall, I think I hear you proposing that we establish two schedules of reimbursement, if you will, one for in-state residents and another for out-of-state residents. And so my first question is, are you aware of any state that has implemented such a program where, for example, the NRA is charged more for records than a local citizen is charged?
So I can't think of any state to answer your second question first. I cannot think of any state that charges different, or that I'm aware of anyway, that allows for different amounts to be charged based on whether an entity is in state or out of state. To the first part of the question, though, I would need to think a little bit more as to whether the disparate treatment would be legal, as far as whether or not we could treat an entity differently simply because they were out of state versus an in-state entity.
That
I would
was,
want to think about that.
now,
before
that
I-
was actually the thrust of what was going to be my second question. I suspect it's constitutionally impermissible to discriminate against the citizens of other states. But if you want that remedy, bring me the law and the cases. We'll think
Well,
about it.
the thing that I was getting at is that Kansas law is unique from other sunshine laws in that it allows organizations and individuals that do not live within that taxing jurisdiction to request those records. So in some states, if you are, for example, a resident of the city, you can request records from the city. But if you live in the town 10 miles away, you cannot request those records. You have to be living a tax-paying resident of that particular taxing jurisdiction.
Okay, thank you. Any other questions? So, yeah, okay, go ahead.
Thank you, Madam Chair. I suspect that that sort of proposal has perhaps even greater constitutional infirmities than the first. Can you point me to states which provide that only residents are entitled to public records and that those who don't live within the city or the county or the state are not entitled to public records? That may be the case, but I've never heard of such a thing.
I do not have those with me right now, but I would be happy to provide that to the committee at a later time.
I look forward to receiving it soon because I suspect we'll be working this bill soon, and I need time to use those examples in working with the reviser to see if we can't broaden the scope of this bill. Thank you.
If you do have that information, if you could send it to our committee assistant, Kathy, that would be great. And then we can.
Certainly, I will get that to you.
Okay, thank you. Okay, thank you. Committee, we also have the next opponent testimony, Amanda Stanley from the city of Topeka. Welcome to committee.
Thank you, Chairwoman. It's nice to be back in Judiciary. It's been a while. Thank you for letting me come testify in opposition. We're in opposition today because even though, as some have mentioned, as drafted, we were told the proponents meant for it to apply to local government. So we just thought we'd save time and be opposition from the beginning. The city of Topeka receives numerous requests a year. I would hazard a guess it's hundreds of requests a year. Lots of those do not go through the city attorney's office. Lots of them can be responded to pretty quickly. We post all our contracts online. You can access them and easily get them. It's easy to get resolutions. We routinely work with citizens, media, to try to make records easily available. As I've listened to the testimony today, I'm thinking maybe we just really undervalue ourselves, but our attorney rate for any attorney to review is only $35. That's all we charge. The city of Topeka per hour. City attorney's office, the city made a policy choice a long time ago to subsidize records to the public. It's in our city code. But records requests are getting exceedingly more complicated. As we move to electronic records and you think about everything that is in an email every day, you think about all of the files, it does take significant amount of time to pull those records. It does take significant amount of time to then review the records. And I think to one of the representative's points, Representative Lewis, this bill is contradictory. I don't know how to make a record available if I don't first find it and then review it. And review isn't optional. There are mandatory things that you cannot disclose in records. If I accidentally lease someone's social security numbers, because those are things we have in city records, there are very real penalties and very real upset people for very real reasons. So we try to work with our requesters to narrow those requests. It is not uncommon for me to email back one of our local reporters and say, look, can we narrow this down? Can you help me try to figure out what you're looking for? Because we're not trying to cause an excessive bill. But if you can help me figure out why you want every email for 2 years that has the word zoo in it, maybe I can help you. And our media is great about working with us to try to figure that out. We routinely don't charge if it takes, okay, yeah, maybe it took an hour of my time, but it's not often that we charge for those kind of things. We try to work with reporters. We try to work with our citizens to make sure that records are available. But there is real time and value that our taxpayers have to absorb with these increasing complicated records. I wish it had been uncommon over the last year for me to not have a record request where I literally spent 20 hours of my time, because I was the lowest qualified person to do that record request, reviewing. And while I suppose we could take months to get a record request out, that doesn't seem like good governance either. So yes, my salary stays the same if I work 80 or 90 hours a week versus, I don't know how many I work now, so I'm not going to guess, like 50 or something plus, I don't know. But I do think our taxpayers like to expect, there's an expectation that their city employees are not working 100 hours a week just to get records requests out in timely manners. We do get these requests from all over the nation. We get media requests, national media requests on a regular basis, especially if you have any kind of high profile case. You do have to review police records, even if you think that you're probably going to end up denying them, because you're supposed to have real reasons for denying them. And we try very hard at the city of Topeka to make our records responses complete. And we cite to legal cases and we give our complete analysis. And we don't charge for that analysis time, and we don't have to give that, but we do anyway. But I get requests from a woman who lives in New York that just really loved an elephant when she lived here and wants all the records on that. That's a real request I get. And I had no idea how many emails have the word elephant until you have to start reading all of them. And so I'm not sure that my city of Topeka taxpayers should really be subsidizing all of the time it takes to search for that. I think they probably think their chief network engineer has better things to do than run those email searches for free. And they probably think their city attorney's office has better things to do than review every email that has the word elephant, because someone just really cares about elephants. We asked her at one point, why do you want these records? We're just legitimately curious. You can have them for any reason at all. And she just really liked the elephant when she lived here. So those are real records requests we get at the city of Topeka. We think the law works as it is, and maybe that's because we're reasonable and we really try to work with people. We get requests for 10 years worth of every claim form that's ever been filed against the city. And in that request, I said, look, we can do that. We can go and pull these at thousands of dollars, or I can give you this Excel sheet where they're all summarized right here for free. It's not the record request you wanted, but it has all the data you want. And I find that 10 times out of 10, the reporters are happy with that. Like, I rarely have any kind of pushback. It is a give and take relationship, because we try to make records accessible. I don't know how you craft legislation to do that, though. I think it takes reasonable people on both sides saying, hey, let's get to an answer that makes it work for all of us. We try to do that, but I don't think banning fees is going to make that solution better. There is no incentive to narrow your request if it costs you nothing to search for it. Why would you not ask for every email that has the word chlorine in it or something like that? Because you can. And you have no incentive to not. On the flip side, I'm not sure how you craft that from a city side to make people be reasonable. I think you just have to continue to stress partnerships, and maybe someone has better ideas than I do. But at this time, I would just say that I don't think that this bill in any form accomplishes that legitimate goal. So happy to stand for any questions.
Committee, do you have any questions from Stanley? Okay, I think you're good. Thank you. Committee, we also have a written testimony from Michael Koss, the city attorney of Overland Park, and Dick Carter from the city of Overland Park. Is there anyone else that would like to speak to Bill 2599 before we close the hearing? Okay, then I'll close the hearing on House Bill 2599, and we'll open the hearing on House Bill 2675. And again, we'll have our reviser give us an overview.
Thank you, Madam Chair. House Bill 2675 enacts the Uniform Non-Parent Visitation Act. Section 1 names the act, and Section 2 provides definitions to be used throughout the act. Section 3 makes the act apply to any proceeding in which a non-parent seeks visitation, including proceedings where the child has a guardian or permanent custodian. The act does not apply to proceedings between non-parents unless a parent is a party to the proceeding. A proceeding pertaining to visitation with an Indian child, to the extent that proceeding is governed by the Indian Child Welfare Act, or a proceeding pertaining to a child who is the subject of an ongoing child in need of care proceeding. A non-parent is not allowed to maintain a proceeding under the act solely because the non-parent served as a foster parent, and a person whose parental rights concerning the child have been terminated shall not maintain a proceeding under the act. Relief under the act is not available during any period of visitation order or other related visitation with a child of a deployed parent. Section 4 provides that a court may order visitation to a non-parent only if the non-parent proves that, first, the denial of visitation would result in harm to the child. Second, the non-parent is or has been a consistent caretaker or has a substantial relationship with the child. And 3, an order of visitation is in the best interest of the child. The bill also provides a list of factors to determine whether that person has been a consistent caretaker or has a substantial relationship. Section 5 creates a rebuttable presumption that a decision by a parent regarding a request for visitation by a non-parent is in the best interest of the child. The non-parent has to rebut that by clear and convincing evidence. Section 6 authorizes a non-parent to commence a proceeding by filing a petition in a court having jurisdiction to determine visitation under the Uniform Child Custody Jurisdiction and Enforcement Act. Section 7 provides the requirements that must be alleged in that petition. It has to state the relief that's sought and allege the facts pertaining to the non-parent's relationship and previous visitation with the child. If the parties do have an agreement regarding visitation, that agreement has to be attached to the petition. Section 8 requires the court to determine whether the non-parent has pleaded a prima facie case that denial of visitation would result in harm to the child, the non-parent is or has been a consistent caretaker or has a substantial relationship, and that order of visitation is in the best interest of the child. If the court fails to make that determination, then the case is required to be dismissed. Section 9 requires notice of the proceedings. They'll be noticed the same as in the Civil Procedure Act to each parent, people having custody of the child, individuals having court-ordered visitation, and any attorney, guardian, ad litem, or other representative appointed for the child. Section 10 authorizes the court to appoint a guardian ad litem, interview the child, require parties to participate in mediation in most circumstances, investigate, and make an assessment of the child's circumstances. They can do all of those things to the extent authorized under the Kansas Family Law Code. Section 11 requires the court, when making a determination whether an order of visitation is in the best interest of the child, to consider several things. Those are listed in my brief and in the bill if you want to read those. The court is also allowed to consider the views of the child, taking into account the age and maturity of the child. Section 12 requires the court to presume that ordering visitation to a non-parent is not in the best interest of the child in certain circumstances. That is, if the non-parent or an individual who lives with the non-parent committed abuse of a child, abandonment of a child, a domestic violence offense, a sex offense, or stalking, if they've been subject to any registration requirements under the Kansas Offender Registration Act, or other KORA, or committed a similar offense or has been subjected to similar registration requirements in another state. Such a finding shall be based on evidence of a conviction, a final judgment in a civil proceeding, or it can be proved by a preponderance of the evidence. A non-parent can rebut that presumption by clear and convincing evidence that ordering visitation to that non-parent will not endanger the health, safety, or welfare of the child and is in the best interest of the child. Section 13 allows the court to modify a final visitation order on a showing by a preponderance of the evidence that material change in circumstance has occurred relevant to the visitation. And again, the modification would be in the best interest of the child. Section 14 requires the court, when issuing a final order of visitation, to make findings of fact and conclusions of law in support of the decision as required in the Civil Procedure Code. If the petition is dismissed or a motion to modify is denied, then the court has to state those reasons as well. Section 15 requires a non-parent who is entitled to visitation to give written notice to a parent if the non-parent becomes subject to the registration requirements under the Offender Registration Act, has been convicted of abuse of a child, or is residing with someone that fits one of those two categories. That notice has to be sent to the parent within 14 days. Failure to give that notice is an indirect civil contempt, and the court can order the non-parent to pay reasonable attorney fees and other expenses incurred by the parent as a result of that failure to provide notice. One of those events taking place also counts as a material change, so that can be considered a reason to change the order of visitation. Section 16 provides that the expense of facilitating visitation shall be paid by the non-parent. The non-parent shall pay for services described in Section 10, and the cost and reasonable attorney fees shall be awarded to a parent or person acting as a parent unless the court determines justice and equity require otherwise. Finally, we have all the typical Uniform Act provisions that we typically see. Section 17 requires consideration to be given to uniformity when applying the Act. Section 18 provides the extent to which this Act modifies other acts. Section 19 applies the Act to proceedings commenced before July 1st, 2024, in cases where a final order has not been entered, and to all proceedings commenced after July 1, 2024. And then finally, Section 20 provides for severability of the Act. And I can take any questions.
Hey, thank you. Committee, do you have any questions for the revisor? Representative Titus.
So just to summarize, this seems like a pretty comprehensive overhaul of a very limited section of statute. Is that a fair summary?
Representative Titus, Madam Chair. So we do have a few statutes on the books that are very specific to grandparent and step-parent visitation. Those can be found at KSA 23-3301 through 3304, and you can see that we're repealing those sections if this act were to take effect. So this act, I guess I don't know if I would call it an overhaul, since we don't have something similar except with respect to grandparents and step-parents.
How many states have adopted this?
I do not know that. I should also mention, and I'm sure that they will get in, that the proponents will get into this as well, but this really is only kind of a portion of the Uniform Act. The Uniform Act also dealt with custody orders, whereas ours just deals with visitation orders.
Okay, committee, any other questions? Okay, Natalie, thank you. Okay, for our proponent, we will call Ron Nelson up to chat with us, a familiar face here in the Judiciary Committee. Welcome.
Thank you, Madam Chair, Committee. This bill comes through the Kansas Judicial Council, the Family Law Advisory Committee. It is the result of essentially a 2-year study of what to do and how to handle third-party visitation, in this bill called non-parent visitation. A bit of history on this matter. Third-party visitation statutes, the statutes that were referenced, were first introduced and passed in Kansas in 1971. There were some adjustments to that in 1974, and then there was the last amendment to it in 1981. Those basically provided for a third-party visitation in the broad circumstances provided by those statutes to grandparents, and then in limited circumstances to a step-parent. In 2000, there were custody and parenting time changes, but no changes to visitation by third parties. In 2010 through 2012, the Family Law Advisory Committee looked at recodification of the family law statutes, since they were spread throughout the Kansas statutes annotated. In doing that, the committee decided, and in consultation with this committee and other legislators that there would be no substantive changes in the recodification of the family law code, simply recodification and then repositioning of the statutes. With regard to the third-party visitation statutes, the non-parent visitation statutes, those were placed in one article. So all of the statutes that appeared in Kansas statutes annotated, which were 4 statutes spread in 3 different articles, came under one article under Chapter 23. It was decided at that time that sometime later, the Family Law Advisory Committee would go back and look at third-party visitation and determine what the committee decided should be done, should be recommended to the legislature. In 2000, I will say, the U.S. Supreme Court dealt with third-party visitation in the U.S. Supreme Court case Troxell versus Granville, which dealt with a Washington state statute that allowed for third-party visitation, not specifically for grandparents, not specifically for step-parents, but for any third party. The U.S. Supreme Court decided that that particular statute was a violation of fundamental constitutional rights of parents to decide that parent's child's who they would associate with, who they would interact with, and that it was the parents' charge to determine what is in their own child's best interests rather than a court interfering with that. A number of the things that the U.S. Supreme Court indicated in that 2000 decision was that special consideration of some kind or other must be given to a parent's decision regarding the child's best interests. There also were some additional requirements that the U.S. Supreme Court placed on third-party visitation statutes. But unfortunately, the justices of the Supreme Court were widely varied on that. There were essentially 9 different decisions with plurality decisions. Over the time from 2000 until recently, different states have handled the issue of third-party visitation in different ways. In about 2013, the American Bar Association Family Law Section took upon itself to start a model third-party visitation statute. I sat on that original committee to draft the third-party visitation statute with the American Bar Association. And that went through the family law section. In the later parts of that, it became a model third-party custody and visitation proposal, which is then what the Uniform Laws Commission took up and what you see variously before you. So what the Judicial Council looked at was the Uniform Non-Parent Visitation Act from the Uniform Laws Commission. In doing our study, the Family Law Advisory Committee very quickly decided that the third-party custody provisions of the Non-Parent Custody and Visitation Act should not be adopted or recommended to the legislature for adoption. And part of that is because we already have third-party custody provisions that are working well. Another part of it is that it was the committee's belief, basically, that you were mixing 2 different concepts that complicated everything much more beyond what we were really focused on, which was third-party visitation. With regard to the third-party visitation statutes that Kansas has, the legislature, again, has not amended the statutes since 1984, other than the recodification in 2011, 12, 13. That doesn't, and the problem with that is that the statutes as they exist and have existed since the 1980s are very broad, do not specify what is required. And just looking at those statutes themselves, they would be unconstitutional under the U.S. Supreme Court's determination of fundamental parental rights. But the Kansas Supreme Court has glommed onto the existing statute the requirements that the U.S. Supreme Court listed, and that is that there must be a special consideration to the parent's determination regarding the best interest of the child and some other criteria. Problem with it not being in the statute is that when you look at the statute, there are filings by people who just say, well, I'm not allowed to see my grandchild, and so I'm going to file an action. There's far too many of those. They end up usually getting dismissed because they don't meet the case law criteria, but it's still problematic. What we attempted to do was line out what the majority of states have looked at in determining what is required with regard to third-party visitation of a parent's child. And that is requiring certain things, imposing a clear and convincing evidence standard. One of the problems in Kansas is that right now it is a balancing, which in other areas of the law, adoption, termination of parental rights, things such as that, there is a higher standard than just a balancing of evidence. And it was the determination by the committee in looking at the Supreme Court decision, in looking at other states' laws, that it was best to impose a clear and convincing standard for evidence rather than just that balancing, which really doesn't protect a parent's rights at all, even if you say that that parent's rights are to be given special interests. One of the other provisions in the Uniform Non-Parent Visitation Act that appears in here and that the committee strongly supported was that in order to get third-party visitation, that there must be some showing by the person seeking the third-party visitation that in absence of that third-party visitation being granted by the court, there would be harm to the child. The majority of the states that have looked at the issue have determined that is another one of those matters that really must be proven by a person seeking to interfere in this family relationship in order to show it's not just I want, but it's this child's best interest is the focus of this case, and that this child would be harmed if not to have this relationship. Now, as was previously mentioned, currently Kansas allows grandparent visitation and allows in certain circumstances step-parent visitation. The committee decided to broaden that from grandparents and step-parents to any third party who met the criteria stated in this proposed statute. And the reason for that is there are a lot of grandparents who really don't have very much, if any, contact or connection with their grandchild, but they have more rights than a person who may have been a non-marital step-parent, if you will, who may have been in the household, raised the child for years, and has much more connection to the child, much more emotional connection, and the child would be harmed if the child didn't have contact with that third party. I will stand for questions.
Okay, thank you. That was a good explanation of a complicated, it's not that complicated, but there's a lot of explanation. Yeah. Okay. Representative Carmichael, you go ahead.
Thank you, Madam Chair. Thank you, Mr. Nelson. It is always educational and edifying to hear your commentaries, and I appreciate the work that you do for us. How, if this bill becomes law, how, if at all, will it impact existing visitation agreements?
The Uniform Act talks about that, and basically existing visitation is existing under a court order. And so it continues on through unless there is a change.
But to the extent the qualifications or the standard of proof may have changed?
Then if there was a modification, then that.
Through modification.
Yes.
This being, I guess, a procedural change in the law, and there wouldn't be res judicata, et cetera, based under a prior statutory scheme. I'm getting in deeper over my head, but.
And one of the issues that you raise with res judicata is that with child custody issues, yes, there is a res judicata element to that, but at the same time, because a child is involved, the original decision is res judicata, but changes with the child over a period of time are significant in making a change to the visitation order.
That is so whether we adopt a new statutory scheme or not.
It is.
We just continue the existing law, change in circumstance will justify revisiting a prior order.
Yes.
Thank you.
And currently under Kansas law, if there is an agreement between the parties that is accepted by the court, then there does not have to be a showing of a material change of circumstances. If it is a court-determined matter that has not been agreed, then there must be a showing of a material change of circumstances. What the courts have said is a material change of circumstances, and one appeal that I handled was we know it when we see it.
Okay.
Thank you, Madam Chair.
Yeah. Representative Heiberger, you have a question?
Thank you, Madam Chair, and it's good to see you, Ron, even if you can't see me. Do you know how many states have adopted the visitation portion of the Uniform Act?
One. One has.
One? Okay. And what state is that?
They're thinking, just a minute.
North Dakota.
North Dakota.
North Dakota. Well, and in further response to that somewhat, I will say I suspect the reason that more states have not adopted the act is the same reason that our committee decided to strike out so much of the Uniform Act. Because when I was on the original ABA Family Law Section committee that drafted the Visitation Act, and then custody was brought into it, there were a lot of objections to that. There were a lot of objections to it in the Uniform Laws Committee because I was on the study committee. Ultimately, it was decided that they'd go ahead with that, and I think that hurt the bill.
Thank you.
Okay. Committee, any other questions? Representative Mon?
Thank you, Madam Chair. I'd just like to summarize my understanding of what this does. Okay, so, and make sure that I have it right. It expands the number of people who might be able to get visitation to the child, but it also raises the burden of proof to show that that's in the best interest of the child. Is that pretty much? Okay, thank you.
Any other questions, committee? Nope. Okay. Okay, I think that's it. Thank you so much. Appreciate that explanation and covering all of that. And thank you to the Judicial Council for being here too. Okay, committee, I will close the hearing on 2675. Tomorrow, we are going to hear about the age verification bill. If we have time, I would also like to work some bills. I'd like for you to write down these numbers just in case. And we have had a lot of written testimony. So if you have a chance to review these, there's 4 of them that I'm considering. Oh, sorry. Okay, I'm backing up. I'm opening back up that hearing. I did not mention that we have written proponent testimony in that, also from Julie Swars, a citizen. So please make sure you look at that. Now I'll close that. Okay, now the bills that we might work, 2549. That was an adoption bill that came from the Judicial Council. 2557. And that was the peer support that we heard from Ed Klump. 2604, that was the small claims, increasing the amount. And 2605, that was the bids that we just heard yesterday. If you have any amendments or you'd like to work on those, please get with Natalie. And if we might not get to work those tomorrow, that's what the goal is going to be, is to do that. Okay, any questions, anybody? Natalie, do you have anything? Okay, then that's it. Thank you, everyone. We're adjourned.